Essentially correct.
Yes, sir.
Counselor, is there any reason why we should not have sentencing?
Judge, I did file a motion for a hearing regarding domestic violence.
I
in
have
the
never had
commission.
one of those. You know,
Well,
Mr. Stockton, what do you have to come around where I can see you here?
Well, I anticipated it probably been filed, but my understanding is the court has to make a determination about whether the domestic violence makes her eligible for shock or probation based on the evidence. And I figured we'd set a hearing because I'll have to have the officer here and some witnesses here.
Okay, we're gonna set it for next month then.
yes, Judge.
Do you want to do it tomorrow or afternoon?
Let's just do it at the end of the docket.
Okay.
That would be August 6th.
Thank you, Judge.
No, I'm gonna go ahead and censor. The hearing will just be for, come back here.
Oh, I'm so sorry.
I'm gonna go ahead and censor and
Oh, I'm so sorry.
that just be a finding that's added. Isn't that right, Mr. Stockton?
That's the way I understand the statute, Your Honor, that
Yeah.
affects the judgment.
Because if I don't, she remains a county prisoner if I don't censor.
Right.
Or plead guilty to manslaughter, first degree, the defendant shall receive a sentence of 15 years to serve. All evidence to be disposed of. This judgment, of course, is subject to a hearing, which will be, the sentencing will be supplemented by the findings of the hearing, which we have scheduled for August the 6th. Okay, thank you very much.
Thank you, Judge.
Yes. Charlotte Brown. Charlotte Brown. Commonwealth versus Charlotte Brown, 25 CR 0087. Are you Charlotte Brown?
Yes.
Born in 1984.
Yes.
Support agent social security number 0160. You're here on a pre-trial conference. Or you can have a plea.
Judge, we have a misdemeanor plea for court to consider.
A motion's been tendered that says you wish to enter a plea. Is that correct?
Yes.
You're currently under the influence of drugs or alcohol. This is plea free and voluntarily given.
Yes.
Are you the same person that we just identified a few minutes ago?
Yes.
Is your judgment impaired today? Have you discussed the charges with your attorney? Are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
What?
Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about your
Yes.
case? You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes.
I'm gonna go over them. At the end, I'll ask you if you understand. If you have any questions, step aside and ask your attorney. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial, jury right to be represented counsel at your jury trial. You right to have to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, the right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter to a higher court if you lose, and you have a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges that you understand. That by entering the guilty plea, that you give up all those rights. You understand that?
Yes.
I may consider Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll order a pre-sentence investigation. This is going to be misdemeanors. You don't have to do pre-sentence. Step to the left. Ms. Gordon Anderson, what's the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, second degree, the defendant shall receive a sentence of 12 months, probated for 12 months, supervised. The defendant shall receive credit for time served. The defendant shall do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Yeah, why are we doing a misdemeanor? Please, she wasn't eligible for pre-trial diversion.
May we approach, Your Honor?
That's okay, I understand. So, is this what you agreed to? Get behind the post. Okay. Are you pleading guilty to the amended counts because you are guilty as charged? You can say something, yes, no,
Yeah,
no, yes.
yes.
Okay. You're doing so of your own free will, correct? And under constitutional rights, it's still your desire to give up those rights and you're guilty of allow court to put your punishment arrangement by law.
Yes.
You understand that? Okay. Is that your signature on the motion now?
Yes.
Yeah, I accept the agreement and the judgment today. Now, is she to be supervised under this probation?
I thought it was.
Thank you.
Yes.
Okay, you need to meet with the probation officer. What are the court costs?
150.
150, need some time to pay that. I'll let you pay first payment 30 days from today and $30 every month you pay it, okay?
Thank you.
Luther Connor. Humble versus, are you Luther Connor?
Yes.
Good morning. This is 26 CR 0001. Commonwealth Kentucky versus Luther Connor. Mr. Connor, were you born in 1977?
Yes.
Last four digits, social security number 5202.
Yes.
5220.
Yeah.
Okay, what do we have here?
Judge, Luther has just made bond. He's been in for some time. My investigator is engaged in the case and work is ongoing. This is one that's likely headed for a trial. I couldn't say that we're ready for a trial just yet, because we still have some work to do on our end.
What's the charge?
Strangulation, so I would think we've asked this a couple of times to investigate. I think the next month, we can set a trial date.
You want to put on a negotiation day next month too?
Maybe be what?
Well, it may not be, but also won't be any work if it's not, so.
Okay, fine.
Well, let's go.
What day did we decide on that?
I don't know if it's going down the head off, so.
Yeah, we're a little testy. Everybody's a little testy. Let's don't start out. Everybody, I don't want to have to order y'all to hug each other this morning, but just let's be sick.
We already did hug.
Already hugged each other? Okay, that's more information than I want. I can tell you
Is
that.
it August 3rd?
August 3rd at 9
August 3rd. August 3rd, you to be here for negotiation. August the 6th is your next court date, okay? Bobby Fulton,
You need to make all next week.
Commonwealth versus Bobby Fulton, 26 CR 0044. Are you Bobby Fulton?
Yes, sir.
Good morning, Mr. Fulton.
Good morning.
You born in 1980?
Yes, sir.
Last four digits, social security number 4889. You were represented by Mr. Turner. What's the Commonwealth have in this case?
Well, Mr. Turner made a request this morning, meeting date case. I know how the sheriff feels about the case and that he was going to talk to the sheriff. I don't think they spoke about it. So I'd say you're probably heading for trial on this case.
What's the charge?
It's a wanton endangerment, multiple counts, shooting at home, allegedly with a police officer.
Judge, actually, and the sheriff and I have played phone tag, things like that. I think he's open to talking to us about it. That's the reason I suggested the mediation. There's a lot of issues, going on. We still have some outstanding discovery as well.
We need to check and see if the body count, state police, one county sheriff's office.
Okay, I'm gonna do it on August the 3rd and
Judge,
August.
I apologize, but I'm not available August 3rd.
Well, you can call me on a different date, but it's.
And that I'm out that whole week. Been scheduled out that week for
The schedule is for trial.
quite some time.
I'm not gonna let
Judge, I'm not,
case like this drag out for
We're-
the
I'm not-
sheriff might decide something. But if there's weapons involved, the officers involved, even if the sheriff agrees to it, doesn't mean I would.
and we're cooperating with that, Judge. In that regard, I mean, if we set it for trial, it's a
I'll sit it
serious,
out a couple months.
huh?
I'll sit it out a couple months.
In that regard, we're gonna have to have some investigation. We've been trying to resolve it. And we're gonna have to look into whether we're gonna need expert testimony as well in that regard. And I'm not gonna know part of that until I get to discovery. That's the reason I suggested mediation.
No, it's not gonna be mediation. You can talk to Commonwealth. You have these negotiation days.
Okay,
We don't have funds for mediators.
well, unless he was waiting on
I don't
that.
know if tax going to approve it, paid until August.
If we can set it for another,
It's a waste of time to mediate this one. Okay, y'all reach an agreement.
if we can set it for a mediation day in September, Judge, and that give
We
me
don't
time to
have
speak.
mediations. We don't
I
do
mean, I'm sorry,
mediations.
a negotiation day in September and a pretrial, then we'll either resolve it or set it for trial.
Set this for September the 10th. What's your negotiation day?
I don't know yet, but I'll notify Mr. Terman, agree on.
Okay. Both of those days. And we'll either have an announcement that day or we'll set a trial date and it won't be long out. The trial date won't be long out, okay? Okay, thank you very much.
Thank you, Judge.
Thank you, Your Honor.
Kenneth Gunter. Are you Kenneth Gutner?
Yes, sir.
Good morning. This is 26 CR 0034. Mr. Gutner, were you born in 1968?
Yes, sir.
Last four digits, social security number 7915.
Yes.
What does Commonwealth have to say in this case?
We need a negotiation on this one. We do have one for September now, which will be August 28th at 9 o'clock. We set both of Mr. Turner's cases for that day. We'll let you resolve, get trials.
August 28th for negotiation and September the 10th for the next pretrial. We'll have an announcement then or set a trial. Knox County, what time is Knox County scheduled?
Yeah.
You're not scheduled to come on for about 30 minutes. Could you turn the camera off till then? Great. We'll do it from here. We'll do it. Okay, thank you. Randall Hicks. Are you Randall Hicks?
Yes, sir.
Good morning. This is 26 CR 0056. Mr. Hicks, were you born in 1973?
Yeah.
Last four digits of your social security number 2625.
Yeah.
You're here today for the purpose of arraignment. You have the right to remain silent. You're represented by counsel. The grand jury of Clinton County is returning an indictment charging you failure to signal, driving on a suspended operator's license, operating a motor vehicle with alcohol concentration of 0.0805 influence, possession of drug paraphernalia, possession of a controlled substance in the first degree. You understand those charges?
Yes.
Counselor, you acknowledge the identity of client receiving indictment, away formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions.
Yes, Judge.
Signing the reciprocal discovery order here, sir, that requires the Commonwealth to provide your attorney information to help prepare for your defense. We'll set a negotiation date on August the 3rd, next court date on August 6th. Okay. Tyler Ledbetter. Tyler Ledbetter. Are you Tyler Ledbetter?
Yes.
Good morning. This is 26 CR 0049. Mr. Ledbetter, were you born in 1991?
Yeah.
Last four digits, social security number 8511.
Yeah.
We're here for pretrial conference. What does the Commonwealth have to say in this case?
Well, my understanding is they're gonna have to get conflict counsel for either Mr. Ledbetter or the co-defendant.
His co-defendant, Mr. Brett, is in custody, so we'll be keeping his case. We're gonna find an attorney for Mr. Ledbetter.
We have the attorney present for negotiations on August 3rd. And here in court on August the 6th. Mr. Ledbetter, you make sure that you give this attorney a good contact number that's still good, so that your new attorney can get a hold of you, okay?
Okay.
Is that right?
You're 22.
Yes.
August the 3rd and the 26th. You need to meet with your attorney before August the 3rd, prepare for the negotiation.
Okay.
It's then August 13th.
It's section, you got it.
Okay, thank you. Teresa Melton. Teresa Melton,
Yes, sir.
good morning.
Good
This is
morning.
26CR0017. Miss Melton was born in 1977.
Yes, sir.
Last four digits of social security number 9501.
Yes, sir.
You're here for a pretrial conference.
Yes, sir.
What does the Commonwealth have to say on Miss Teresa Melton? I've just been informed that you filed a motion that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
The same person that we just identified in 26CR0017.
Yes, sir.
Is your judgment impaired today?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you, believe you're fully informed about your case? You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can proceed, I need to know that you understand what I'm going to read over. If at any time you have any questions, step away and call me and inquire of your attorney. You have a right not to testify, but shall no one can make you say anything right to speak trial or jury, right to represent counsel to jury trial. The right to confront and cross-examine all witnesses called to testify against you. Right. So this right to all witnesses in favor. The right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt you're guilty of charges against you. You understand that by entering a guilty plea today, you waive all those and give up those charges. You understand that?
Yes, sir.
And may consider the Commonwealth's recommendation of the claim range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll wait the pre-sentence investigation report from probation and parole. In the event I do not accept the recommendation of the Commonwealth and decide to impose a harsher sentence, you have the right to withdraw your plea if you proceed to. Step to your left. Ms. Gray, what is the Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 3 years, probated for 5 years, supervised. The defendant shall enter and complete a long-term treatment facility determined by DPA and agreed upon by the Commonwealth. The defendant shall be transported to the facility by probation and parole. The defendant shall receive credit for time served. The defendant shall do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
One step behind the podium. Is that your understanding of the Commonwealth's offer?
Yes, sir.
Are you pleading guilty because you committed the acts charged in the indictment as amended?
Yes, sir.
You doing so of your own free will.
Yes, sir.
You know, your constitutional rights explained to us, it's still your desire to give up those rights, enter a guilty plea and allow the court to fix your punishment in the range permitted by law. You understand that after entering this plea, the future convictions could be enhanced under the persistent felony law. Understand that? Is that your signature on the document?
Yes, sir.
I accept the agreement order for the sentence investigation report to be done by probation and parole. And schedule sentencing August the 6th. Okay,
I guess I've been confused. Are we August 6th or August 13th?
says August the 6th. What says on my list here?
All right, well, I've got a couple people I have to contact. Jesse and I don't know why we were thinking it was 13th.
No, August the 3rd is negotiation. I knew August 6th was the motion.
I don't know. Doesn't matter. August 6th.
Normally it's the second Thursday that we put it in the Thanksgiving on books.
Okay, August 6th.
Kyle Norris, Kyle Norris. Caldwell versus Kyle Norris, 26CR0004. Are you Kyle Norris?
I am.
Good morning.
Morning.
Were you born in 1988?
Yes.
Last four digits, social security number 9777. Is that
Yes.
correct? This is a motion to revoke bond.
Yes, and a pre-trial.
Says he's represented by Ken Garrett.
We said 30 minutes, so I figured you'd walk in the door anytime.
We'll take a seat back there. Tiffany Perkins.
He's never on the court, been court on time. He's getting.
Commonwealth of Kentucky versus Tiffany Perkins. 26 CR 00050. Tiffany Perkins, good morning. You were born in 1987, last 4 digits of social security number 8629, you're here for pretrial comment, plus Commonwealth episode.
We have a plea, right?
Felony plea.
Yes, Judge.
A motion's been tendered, and I've just been informed you wish to enter a plea today, is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 26 CR 00050?
Yes, sir.
Is your judgment impaired today in any way?
No,
Have
sir.
you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you during your full informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I accept a guilty plea, I need to know that you fully understand those.
Yes, sir. I'm
I'm gonna go over them with you. Every time you have any questions, step away before you ask your turn. You have a right not to testify against yourself. No one can make it right to speak trial by jury. But be represented by counsel to secure trial rights to confront and prosecute and all witnesses called to testify against you. Right to produce evidence, right to call witnesses to pay the right to tell us no matter how to lose. The right to declare the Commonwealth to you on the rules without you guilty charge against you. You understand that, but when you plead guilty, that you give up all those rights. You understand that? And may consider the Commonwealth's recommendation, but I may apply a range of sentence for private law. I don't have to accept the recommendation prior to accepting the recommendation all the way to pre-sentence investigation report done by probation and parole. I do not accept the recommendation of the Commonwealth and decide that it's a harsher sentence. You have a right to withdraw your plea of guilty and proceed to trial. You understand that? Step to your left a little bit. It's Gordon Anderson. What's the Commonwealth's recommendation?
Upon a plea of guilty to wanton endangerment first degree, the defendant shall receive a sentence of 5 years, serve 82 days in jail with the balance probated for 5 years supervised. Upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08, or while under the influence of alcohol or other substance, first offense aggravating circumstances, the defendant shall pay a $250 fine and serve 4 days in jail. The 82 days and the 4 days shall run concurrently for a total of 82 days to serve. The defendant shall receive credit for time served. The defendant agrees to have any and all evidence of the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
You understand on the DUI plea, you also, that's enhancement. You get another DUI.
Yes, sir.
In addition to the felonies, you understand that? Are you pleading guilty to the action, because you did are you pleading guilty to the charge because you did commit the acts charged in the indictment?
Yes, sir.
And so your own free will, no constitutional rights, still desire to proceed, give up those rights, you have to plead guilty and allow the court to fix your punishment. Is that correct?
Yes.
And by entering guilty plea, any future convictions, I told you, to be enhanced on the felony and the DUI. Is that your signature on the motion offer?
Yes, sir.
I accept the agreement or the pre-sentence investigation report. Does she have some time to serve now?
No, she has 82 days.
She has it already in. Okay, so you need to meet with the probation parole officer. We'll be back here on August the 6th.
Question, you're on the service fee also,
Yes,
total cost $830.
$830. And I'll tell you how you can pay that when you come back at sentencing, okay? Travis Powell. Morning, Mr. Clerk. Are you Travis Powell?
Yes, sir.
Good morning. This is 26 CR 0021. Mr. Powell, were you born in 1989? Last 4 digits, social security number 7323. Okay, you're here today for a pre-trial conference plus a Commonwealth.
You're not. It's a felony plea. And before I go, you go through the recitation, I want to know if it's acceptable to court or not, because it's possession of a handgun, and a convicted felon.
Yeah.
And I have offered 5 years probated for 5. My understanding is he lives in, the only reason I did that is he had it in 2009. He had possession of stolen property, otherwise it has a clean record. He had a loaded 9mm marijuana installed, so you don't want to do that. Why didn't you have to go through the court?
Yes. Just a trial, then.
Judge, before we move on, make a statement. in support of the plea.
Sure, you got it.
Well, a couple of things. First off, the court was generous enough at his arraignment to allow him to be released on some low-level bond, which allowed him to keep his job at Tyson. He has remained in good standing there, which, as the court knows, they have a strict attendance policy. If you get a certain number, you're gone, no questions asked. He's remained in good standing there. Secondly, this was not a gun he was aware of. It's not a situation where he's shooting a gun or out pointing a gun at anybody. He was not aware of it. It's his wife's gun. Again, the felony was from long ago. He's done very well out on bond, kept his job.
What was the offer you made?
It was 5 years on possession of firearm, we could tell supervised for 5.
Was this his wife's vehicle he was in?
I don't remember. Do y'all, but y'all don't have two vehicles.
No, we share the vehicle.
I'll take that back. It's a possession of the hand. Big felons, C felons. So that's what did the plea. That's what it was plea. So
How long did you, 5 years?
it's 5 for 5. We could increase the amount of years, but we could increase the probation.
Have we ever had a situation where people serve some weekends or something like that?
We used to do that, and then we started having problems with jail with people bringing stuff in. But I don't think we've done it while, drug court still does that.
Well, let's pass this to the next group day and see if y'all can work something out. You know, saying, 10 weekends, something like that. And I'll do 7 years probated for 5, 10 weekends in court costs. I don't want you to lose your job or anything, but I have to take these firearm things very seriously.
Fully understand.
Okay, thank you very
So
much.
can
We'll
we set
see
it
y'all
on that
back here.
negotiation?
Yeah.
Negotiation day on the 3rd and next court date on the 6th.
August.
Yeah.
Desiree Riddle. Commonwealth versus Desiree Riddle, 26 CR 0038. Are you Desiree Riddle?
Yes.
Born in 1994.
Yes.
Last four did your social security number 5786.
Yes, sir.
You're here for sentence.
It's correction.
Have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yes.
Is it substantially correct?
Yes.
Is there any reason this lady should not be sentenced?
No judge.
In charge of possession of controlled substance, 1st degree, 2nd offense, the defendant shall receive a sentence of 3 years, probated for 3 years, probation be supervised. She agrees to be assessed and following recommendations of social service commission. What is the court cost?
What's it about?
You need some time to pay that.
Yes, sir.
They pay $30, 30 days from today, and $30 every month until it's over. You need to be on probation for a while, okay? Jason Savage. Jason Savage. Commonwealth versus Jason Savage, 26 CR 0028. Good morning.
Good morning.
Are you Jason Savage? You born in 1981? Yes. Last four digits of social security number 3024.
Yes.
What does the Commonwealth have to say, Mr. Savage's case?
I guess we need a pretrial conference and negotiation day since he has conflict counsel now.
Okay, do you have your calendar with you?
Sir, I don't, but I'm okay.
August the 3rd would be a negotiation day here at the Justice Center at 9 o'clock. And August the 6th would be the pretrial. To make an announcement if you can work and bring it out on that day, okay? Both those are conditioned to bond. Okay.
I'm joking. I'm sorry, I'll do an entry.
You go ahead. You gonna do a written entry agreement?
I can.
Or just tell us your name and what your
Okay.
address is.
It's Leslie, Leslie. The last name is Ayers. It's 109 South Second Street, Nicholasville. It's the office, Kentucky, 40356. The number's 833-514-8978. My email is LES.
You don't need the email.
I don't need that, sir.
Yeah, just put it on any please your file. If you have it, or anything, put your.
You said last night that problem was 891.
Wait a minute, 833-514-8978.
You're one of the few people I know that know their phone number because they're all on the phones now. Nobody knows- I don't even know my phone number. Okay, well, thank you for being. We'll see you here. Make sure you have plenty of time to consult with your attorney before the negotiation. Okay, thank you. Jada Shelton. Commonwealth versus Jada Shelton, 26 CR 0038, 26 CR 0039. Are you Jada Shelton?
Yes.
Good morning. The last four digits, social security number 5332. What's your year of birth? 1988. Okay, what's the Commonwealth have to say about Miss Jada Shelton?
pretrial diversion, please.
Okay,
Judge, actually, we do have a pretrial diversion offer. I need a little more time to discuss this with her, and I asked Mr. Stockton if we could set it over for our negotiation day and our pretrial day in August.
what kind of charge is she in, please?
It's 2 possession charges.
I don't. Nothing's gonna change, you know, sometime. When I go to these other dockets, once you go back and talk to her. We'll call you back up, Michelle. Justin Smith. Commonwealth versus Justin Smith, 25 CR 0012. Are you Justin Smith?
Yes, sir.
Good morning. Born in 1976.
Yes, sir.
Last four digits, social security, 5761.
Yes, sir.
Says a motion to continue. What is this?
Judge, this also involves another defendant, Ms. Gallen, who was at, I think, Knox County.
Okay, you turn to Knox County, will you turn your camera on now? You're still on there.
No.
When I told them to turn the camera off, they left.
We told them that they had half an hour, so they're gonna be called.
Okay, well,
I don't know if you want to just go and proceed. Okay.
yeah, this is got Mr. Smith.
Judge, Ms. Gallen is a co-defendant. We recently got counsel for her. She's at Knox County. I don't think they've actually met, and I think Leslie has just gotten the discovery this week on that. Mr. Smith and I have had a chance to meet a few times, but I inherited the case as a sentencing. So I didn't
Schedule for the 18th and July 15th.
right. It was July 15th is the trial date.
What you're trying to get around to is you want to continue.
That's correct, Judge.
Okay, well, we can do that. New
Yeah, I
counsel.
would like to get both of them set trial same.
August the 28th for a pretrial, and then for negotiation in September the 10th. Can we do it sooner than that? Can we do the August 6th one, you think?
Well, the September's fine, if we don't have a result, I can withdraw.
Okay.
But council time, let's speak on that.
Sir, do you want me to wait till she comes back on Zoom?
I think it would be good so
Yes,
she
sir.
would see the
Yes,
presence.
sir.
Okay.
Okay. I'll step back.
Mr. Payne says he's not, he's getting on.
Oh, you're supposed to. Okay. We can do updates. Okay.
Producing the trials pages for this would be.
Yes. Okay.
Knox County, that's right.
Yeah, they said they would.
We'll just inform them when they are, so. Rachel Thayer. Thayer.
That's expunged.
Expungement, is there any objection?
No objection, Your Honor.
Or Stephanie Gray? Come over, Stephanie Gray, 26CR0023. Are you Stephanie Gray?
Yes.
You were born in 1984?
Yes.
Life religious, 8560, correct?
Yes.
Good morning. What does the Commonwealth have to say about Stephanie?
We have a two-trial version plea, I believe.
That's right. A motion has been tendered. It says you wish to enter a plea. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you? You believe you're fully informed of it?
Yes.
You understand that you do not have to enter a guilty plea, but you have certain rights under Kentucky United States Constitution before I can accept the plea. I need to know that you understand those rights. You have a right not to testify against you. No one can make you say anything right to speed trial, but you got to be represented by counsel at your trial. You can find and cross examine all witnesses, call the testify against you. There's evidence, right to call witnesses, your favor, right to not, you got to feel this matter how I feel if you lose, and right to further Commonwealth with you, reason that you're guilty of charges against you. Understand that, doesn't mean guilty plea, they always right, you understand that?
Yes.
And they consider the Commonwealth's recommendation, and they want to, I don't have to accept the recommendation. In the event I do not accept the recommendation after reviewing the precinct's investigation, going inside and posting extra sentence, you have a right to withdraw your plea and proceed to trial. You understand that?
Yes.
Now, I'm going to do some qualifying questions. Have you previously been diverted in the last 5 years?
No.
You had any felonies in the past 10 years?
No.
You have any, are you on probation?
No.
You understand if you successfully complete the diversion agreement, the charge will be dismissed per trial and record expunge. You understand that? You also understand if you do not successfully complete the diversion program, you will be brought back in front of the court and it's scheduled for a sentencing. You'll be a convicted felon. Understand that? Ms. Gordon Anderson,
Yes.
what's the Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance, first degree, methamphetamine, first degree, the defendant shall receive a sentence of 3 years, pretrial diverted for 3 years supervised. The defendant shall be referred to a social service clinician and follow any and all recommendations of the clinician. The defendant shall receive his credit for time served. The defendant shall do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to?
Yes.
Are you doing so because you did commit the acts that you're indictment to me?
Yes.
You doing so of your own free will?
Yes.
The constitutional rights explained to you is it's still your desire to proceed with these charges and allow the court to fix your punishment. You understand, as I told you before, if you violate and you have, this could be enhanced in future convictions of felons. That's your signature on the motion there.
Yes.
I accept the agreement, sign the diversion order. Now, you'll need to meet probation, but what are the court costs?
155.
155, you need some time for that?
Yes.
The first payment will be 30 days from today, 30 days every month you pay for it, okay? Meet with the probation. Cameron Wright,
They could get off on. Make it listen.
okay. Yes, we go back to Jada Shelton, is that right?
Because I had a chance to.
Okay, let's,
Kyle.
Kyle Norris. Number versus Kyle Norris, 26CR0004, you are Kyle Norris. You born in 1988, last 4 digits, social security number 9777, is that correct?
Yes.
Motion to revoke bond, what's the Commonwealth have to say?
Your Honor, that
And
is-
conflict, right?
He was on home incarceration and D-Tracks filed a report. Basically, he was on working church or doctor. Mr. Bookout says on 531, he traveled numerous locations throughout Albany without permission. Traveled on 531, did not pertain to work locations. GPS track points show that he traveled multiple locations throughout Albany. McDonald's, Shell parking lot, girlfriend's residence, and more. So it's violated his.
Just on that one day, or was there other?
Well, it's those 2 days is the two he referenced. No, I'm sorry, the 531, that's all on 531.
Judge, I'd like for him to testify before we permit.
Will you stipulate to what?
I'll stipulate that there were some allegations he had.
Raise your right hand.
Yes.
Testimony about to give us the truth, whole truth, nothing but the truth.
Kyle, can you explain to the court what happened on May 31st?
You need to get in front of the microphone and speak up.
I know it was on Sunday and I had permission to go to work and everything, and if I couldn't get a hold of him, to just go ahead and do it and send him a text message or something to let him know. And my girlfriend's mom had a problem with her toilet. It was leaking sewage into her bathroom. And I was the only person that she knew to call to help her fix it. And we had a hearing up here to make sure I could go through with, be around with me or her moms. And I honestly thought I had permission. I wasn't until they accused me of breaking my bond. I didn't know. I've been staying home, not even going to work.
But we
much
have this
anymore.
set for a trial.
No, Your Honor, this.
Wait just a second.
Yeah, no, it's not set for trial. I've been trying to get this case settled along with the companion case. He was indicted in January. I don't know when Mr. Garrett got trial in the case. I'd probably already set it for trial if I hadn't had some health issues. But
What's the charge for trial?
this case, 26 CR4 would be the case if they tried.
And
What's the
Judge,
charge there?
It's burglary and theft.
and Judge, I think we may have a resolution. We just have to talk one more time, get permission from the alleged victim. There's some restitution amount as well.
Can I have my offer and I'll give you credit for time served on his bracelet. Come up with the rest of it.
Yeah, and that's, and we
Wait
got,
just a second.
$6,500.
What was the circumstance?
He's alleged to have stolen property from this young lady's father's estate. He brought part of it back, but part of it was damaged. And part of it was not brought back.
Okay, have a negotiation day on August the 3rd. And on August the 6th, if there's not a resolution, we will set a trial there. Okay. Yeah,
I think it'll resolve.
you what?
I think it'll resolve.
I'm glad you do. I'm glad to have it resolved.
It's going to resolve one way or the other.
We'll get it resolved.
Okay. As far as this going around thing, are you working now?
I was, I've been afraid to leave.
Where are you working?
My aunt is redoing her house, remodeling her house, and I'm been overseeing that.
Well, I'm gonna overlook this thing, but I'm gonna tell you, you need to get careful.
And I appreciate it.
Okay, no problem.
Thank you, Judge. Here's copies of papers. I've got. Yes. I'll work this out.
Are you ready on Jada Shelton?
Yes, sir.
Jada Shelton. I will go to Jada Shelton. 26 yards, 38, 26 yards, 39. We previously identified this Shelton. What does the Commonwealth have to say in this case?
This is what he's going to.
Yeah, they've made a diversion offer and I've talked to Ms. Shelton and at this time, she's not in agreement to accept that, so.
Okay, we'll set a trial.
Judge, I would ask for a little time on it because this has been headed down the road 4 to for the plea up until a few minutes ago, so.
Gosh.
Um,
She had an opportunity to take, now we're gonna see the trial. Just not related to this, but this trial on the 15th, I think we just continue, right? Yeah, yeah, talking about the. I'm stuck. Mr. Stockton is the trial on July 22nd, Monroe County gonna go. I don't, let me check real quick. Couture, trial, couture.
I doubt it will, Your Honor, because we think we haven't got the DCBS written to furnish them still.
Judge, I would ask to go into August if we could. That's only 2 weeks. That's less than 2 weeks. That.
What about Commonwealth versus Pickens on the 5th?
That should go, I don't see why.
Pickens and Monroe County.
We also have some inside.
Irish is gonna settle. She's actually on her plea.
I
Motion
don't
made.
have that on my thing.
It's Red Rice, I can't remember her last name, filed a motion in her plea, so she's gonna accept the offer.
We have court here on Tuesday, Chair.
Yeah, what day?
28th. July. So we have the 28th of July already, that gives you 3 weeks.
It looks like it's serving on one of the cases.
There's, that. Test negative, someone testifies, they're gonna be able to present evidence of a positive test. So. Why don't you let us share, she's died, but you're gonna do.
What kind of problem are you having?
Judge, as the court might imagine with a pretrial diversion offer, I don't understand or necessarily agree with going forward to a trial, although that's her right regardless. So that's what she wants to do. So.
Okay. What day was that? July 28th. Okay.
Just.
But there are 2 cases, so I guess we need to pick.
You need to elect which one you're gonna try.
28 CR 39.
Can try the other one.
I don't know that long.
That's one on both ends, the written do, I don't have signed. Well, I don't have signed,
Okay, see you on that day.
If we change it to. Yes. Well, I mean, I don't know that I can try.
Okay, let's call the Knox County case, the Knox County change to Commonwealth versus Gowan.
Okay.
Are you Amanda Gowan? You need to turn the microphone on, Amanda. Are you Amanda Gowan? You need to knock on the door and get someone to help you turn the microphone. If you're not involved in Amanda Gowan's case, you need to turn your cameras off. There you go. Commonwealth versus.
Can you hear us?
Yes, we can now. Thank you. Commonwealth versus Amanda Gallen, 25 CR 00119. You are Amanda Gallen, correct?
Yes, sir.
Born in 1984. The
Yes.
last 4 digit social security number 5135. You're represented now by Miss Ayers. Miss Ayers, Miss Ayers, you say something so the voice activated, she'll see you there.
Hi, Ms. Gowan. I'm your conflict attorney. I talked to you just a little bit.
Okay, not clicking in, but she.
Okay.
Oh, there it is. Okay, good deal. So what dates?
The last time social is wrong, that, it's 5131.
5131. Yeah.
Yes, sir.
84 5131. Okay. Okay, what dates did we set for this, Miss Ayers, a few minutes ago? Remember?
Judge, I don't, I just,
August, was this August 28th and September 10th? They'll have a negotiation day on August 28th here at in the Justice Center in Clinton County, and your next court date, September 10th. Both of them will need your presence, and Miss Ayers, it's our practice for defense counsel to prepare a transportation order
yes, sir.
and submit it, and we'll have her
Yes, sir.
so I would assume you'll probably visit her sometime before that. Is that correct?
Judge, I will, but she told me I'm not familiar with the area, but wherever she is, she says she's finished there. So I guess she'll be transported somewhere else. So,
Well, she'd be in Russell County, which would be closer for you.
okay,
If she was
sir.
transported. So you want to call Russell or Wayne County. one or the
Okay.
other. So, Ms. Gowan, when you get transported, you need to contact your attorney and tell her where you are so she can make arrangements to come see you. Okay?
Thank you.
Okay.
Thank you, sir.
Your trial is continued. You're not gonna be tried next week. Your trial is continued until after these negotiation days, okay?
Okay, thank you.
Thank you.
Okay, I'm gonna have to take a small break here. We have a disaster meeting of Cumberland County, so if you're on the line, we won't be very long. Let's go off the record. Yes. Let's go to Jackson County. Jackson County, Commonwealth, Gary Flannery. Are you Gary Flannery?
Yes, sir.
Okay. You born in 1978?
Yes, sir.
That's 4 digit social security number 5544. We're here on a probation revocation. What does the Commonwealth have to say?
Your Honor, Mr.
You need to
Flannery
come
has
back
a,
up to the microphone. Thank you.
he has a 5-year sentence for one endangerment and assault third. And he has a new misdemeanor arrest at McKee Police Department. And I didn't have any witnesses available, but he's accused of pulling a woman's hair at the ballpark. When they arrived on the scene, she was identified as Minnie Flannery. And said that they'd been fighting all day. He'd been hitting her in the ear and pulling her hair, had a scratch on her face. All I know to do is if he wants a hearing, I'll subpoena these people out here.
Judge, I didn't know he was Jackson. I've been looking at Wayne and,
You want to hear him?
well, I don't know if he does or not, but I probably would ask to set it over for next month so I can find out.
Okay, we will set this over until August 6th. And what's he being held in Jackson County on? This charge, the new charge?
Judge, last time I looked, he had a bond on his new arrest. He had a 10,000 full cash bond on his new charges.
Okay, well, let's put a hold on in case he makes.
He's already got one.
Okay. We'll see him here then on August the 6th.
Mr. Flannery, I'll be in contact either by phone or otherwise, okay?
Jackson County, thank you for your cooperation. You may be excused.
You're welcome.
He needs a witness to appear by Zoom, Your Honor.
Yes.
Okay.
Now, Dr. Jim Anderson is on there, it says.
Well, are you going to stipulate?
Which case is that?
That's a Spencer Outhouse
Where's he located here?
at Clinton County Jail.
Russell County.
Oh, Russell.
Is Russell County on there? Russell County, are you on?
They're not on that.
I can, give me just a second.
Now, do you want to wait till your client is on before we have a stipulation? Or
I've talked to him about it and told him that that's what I intend to do.
Dr. Anderson, it would appear that there's a stipulation as to competency and you may be excused. Thank you for.
Thanks, sir.
Thank you.
Thank you, Your Honor.
And we'll go ahead and call that when we get Russell County on. Is CTS on there? In Wayne County, you're on there. Wayne County, you turn your camera on.
Can you hear me?
I can hear you, but I can't see you.
Hold on, let me get.
I got
Can
you.
you hear me?
Yes, Commonwealth versus Haley Harbor. Are you
Haley
Haley
Harbor.
Harbor?
No, let me get.
Haley Harbor?
They need Haley Harbor.
Gary, come in, because you have it.
I want to,
Yeah, you think there's one long-term treatment?
no, right.
They're good. They're good.
Okay, we'll do Jonathan Ray while Haley Harbor's on the way, okay? Commonwealth versus Jonathan Ray, 26 CR 00. You are Jonathan.
Yes.
Are you done?
Were you born in 1986?
Yes.
Last four digits of social security number 4463.
Yes.
Okay, what's the comment?
Your Honor, Mr. Ray's at state at this point in time. He may be coming up for mandatory
If you
release
get behind the podium.
in September. We just asked to pass this to the September rule day and.
September, pass this case to September 10th. You need a negotiation date.
Yes, August 28th.
August the 28th for negotiation, September the 10th. I guess they gotta see what the state does with it before then, and we'll do a transportation down there, okay? Thank you.
Thank you. Thanks.
Haley Harbor there now.
Yes.
Y'all hop on court.
Commonwealth versus Haley
All
Harbor,
right.
24 CR 0089. You are Haley Harbor,
Yes.
born in 2000.
Yes.
Last four digits, social security number 6213.
Yes.
Okay, we're on a shock commercial revocation.
Your Honor, I don't think there's any contest of the facts in this. In June and late May, Ms. Harbor was drug tested twice. Both times she was positive for methamphetamine. She denied use. The labs confirmed that it was methamphetamine. And then she admitted to the probation officer, Derek Morrow, that she used methamphetamine.
Okay.
It was just one drug test. I only had one dirty, not two.
Okay, I misspoke. She admitted to using meth on 2 to 3 occasions.
Okay, what do you have to say?
Judge, I've already started talking to the Commonwealth about finding a placement for Ms. Harbor. A potential long-term treatment, as a resolution to this motion.
How long is she on probation still?
So she was shopped out. It's not been too long ago. She's got quite a bit of time left.
She's probably got at least 3.
It was July 2nd. So,
If it's agreeable, you define a long term.
yeah, my understanding is she's pregnant. She needs to be placed somewhere where she can be seen about and may be high risk, so.
Okay, well, y'all reached by agreement, contact me, send me an agreed order. Hey,
Yes.
if we send you to a drug treatment place and I find out that you've been taking drugs with that baby in you. it's not-
I will not.
Okay, well, I hope you don't, but I'm just making sure you and I understand each other, okay?
Yeah. Yeah.
Okay. I hope you'll protect it, and I know I will if I get a chance. Okay?
Thank you.
Yeah. April Russell. Commonwealth versus April Russell, 25 CR 0069. Are you April Russell?
Yes, sir.
You born in 1990?
Yes.
Last four digits, social security number 0500. Is that right? 0500, 4 digits. You're on.
Yes, sir.
Most of the time I have to
She
say.
had a 2-year sentence on possession of controlled substance first degree. She completed long-term rehab at Marion Pure and at the 1st of June of this year, and then she was positive for methamphetamines on she admitted to use of methamphetamines on June 12, 2026. And that's the basis for the revocation.
Judge, I've talked to Ms. Russell and also Mr. Stockton about a drug court application to see if she would be eligible. She is willing to do it if they're willing to have her.
What do you say, Mr. Stockton?
Well, I don't mind her doing that as young as she is, to give her an opportunity. I'm trying to see how long she's got on her probation period because I don't want her to run out of time on her probation period.
It's not scheduled to end until 2030, so I think
I don't think that's right. But it's just a.
that's just what it says right there.
She's 2 years, it was probated for 5 years, you're right, so, okay.
And
Okay,
just,
well,
she's also got.
I'll do a
one case.
referral to drug court. Ms. Russell, are you willing to work hard on the drug court situation?
Yes, absolutely. I just made a mistake, but
We all
it's not
made,
gonna happen again.
you don't need
Yes.
to make another one. So I'll
This is my last.
do a referral on drug court. They'll vote you in or out and if you get in, they'll schedule for orientation and you'll get out the morning of the orientation if you're accepted, okay? Your
Okay, thank you.
attorney will come and explain. Does that finish what we have at Wayne County? Can they be excused? Wayne County, thank you for cooperation. You may be excused.
You're welcome.
It's Clinton County, Rodriguez, Kelvin, Rodriguez, it's that process.
Okay, I just got, 2 little things here that finish Russell County and I'll go straight to Clinton County. Yeah, 3. Spencer Altwood. Spencer Althouse, excuse me, Spencer Althouse. 25 CR, this is in Russell County. Russell County, we turn Austin, DC in here. Okay, Spencer Althouse.
Yes.
Your attorney was here earlier and stipulated that you are competent, so we're not you're here still. I thought the other way.
Yeah,
Yeah. So what date did you reschedule for that? 28th, and do you have a co-defendant?
no,
That was
he's
the
got,
other case.
that's right.
So what date you want to schedule him?
I'd like to,
Let's do August 6th because he's been in jail for quite a while.
and I might have him transport that day, maybe we can have an argument.
August the 3rd for negotiation day and August the 6th. We're gonna try to advance you because you've been in jail for quite a while, so your attorney's gonna come see you and see if we can't get it speeded up a little bit, okay?
Yeah, thank you, Your Honor.
Thank you very much. Taylor Phillips.
Your Honor, they're getting her out of the kitchen. Can we go ahead and Mr. Shelton?
Sure. James Shelton. Clinton County, when we come to you in just a few minutes, you need to have Mr. Rodriguez ready. Kelvin Rodriguez Riviera, because we got an interpreter lined up for that, okay? Commonwealth, are you James Shelton? Are you James Shelton?
Yes, sir.
You born, this is 25 CR 0097. Mr. Shelton, were you born in 1963?
Yes,
Last four digits, social security number 8382.
yes, sir.
Okay, what do we have on Mr. Shelton?
This is a case where Mr. Sheldon, we mediated the case, we thought we had a plea, and when he decided not to take it, I just like the trial date, maybe out in September or October.
Judge, that's fine. We have some discovery to review. I still think there's a chance for resolution. The biggest piece of discovery that there is in the case, at least from the prosecutor's side, I was supposed to be able to show it to him yesterday. Due to technological problems, I wasn't able to, so I do think there is a chance we could
You want to
resolve.
wait one more month?
Or wants to do this, okay, he's not going.
Either way is fine.
Let's put him on the schedule for August 6th. And if y'all feel like there's any need for a negotiation day, you can go ahead and schedule it on the 3rd. Okay. Okay, your attorney will be over to see you, Mr. Sheldon.
Okay, thank you.
Taylor Phillips for sentencing.
Because it's passed. I didn't know, for some reason, something odd, it was scheduled out. I don't need. Hey, I remember that now. And hey, I may have not,
Y'all are picking up on the camera, on the call, unless you want to hear it again. Okay, this is Commonwealth versus Taylor Phillips. Are you Taylor Phillips?
Yes, sir.
This is 21 CR 0042. Ms. Phillips, were you born in 1997?
Yes.
Last four digits, social security number 5260.
Yes.
Sentencing. Have you had an opportunity to look at the pre-sentence investigation for number probation?
Yeah.
Is it substantially correct?
It is, Judge.
Okay, on June 13th of 2024, a pretrial diversion was granted. On May the 7th, the previously granted pretrial diversion was voided. Now it's stand for sentence. Do you have anything you want to say before she sentence?
I do, Judge. We have reviewed the PSI. I actually reviewed that with her on June 3rd, and I think she's had a chance to look at it again this morning. I I felt like on May the 7th, I made a pretty vehement argument that that the pretrial diversion should not have been set aside at that time. This was a situation where she made her allotted appointment time, passed the drug screen that day, and she ended up getting a warrant and a motion to revoke before her next appointment date even came because her husband was, I guess, wanted as a fugitive from probation, and in the midst of not being able to find her husband, they couldn't find her either. And I feel like, she should be probated today. In addition to all that, she served an extra 30 days because rather than her sentencing being on June 4th, it's today. So there were 60 days in between her
Mr.
revocation.
Stockton, do you feel that I should revisit the pretrial diversion revocation?
Your Honor, to be perfectly honest with the court, I think Miss Purdue or Miss Phillips has gotten caught up in her husband's problem. He has been the one that whenever he gets in trouble, he's gone. We've been through that 3 or 4 times. I know he's gonna come up for shock.
You're gonna set aside the previous order?
That's fine, but
I'm gonna set aside the previous order.
But I'm gonna be vehemently opposed to his shock probation. I just tip you
Well,
off.
you're using my word.
I'm gonna set aside the previous order, ma'am, revoking your pretrial diversion. So we're going, you can still get out of this and not be a convicted felon, okay? But you can't let anybody else in this world drag you down. Some people you can't change.
Right.
I hope we all have a chance to change, but you can't change, right?
Right.
Okay. So if you'll submit me an order, and then you'll need to meet with the probation and parole officers when she gets out, is that correct?
Taylor? Yes. As soon as you're released, if you get released before 2 p.m., report that day to the Monticello office. If you get released after 2, report the next business day.
Okay.
All right.
Okay, thank you all.
Today, I'm gonna release you. I'm gonna try to release you today unless you wanna go back and finish your work in the kitchen and get out tomorrow. Would you rather do that or?
I would rather if I could get out today, I would rather get out today.
And we won't have a competency here in our meeting, so you want out today. Okay, well, listen, don't let us down.
I won't, I promise. I will.
Okay,
I'll
okay,
do my best.
okay, see you later. Okay, that finish everything that we have over there in Russell County. I'm seeing if there was anything else. Thank you, Russell County, for your cooperation.
Thank you, Your Honor.
Okay, let's go to Clinton County and go to Mr. Kelvin Rodriguez Riviera. We got the interpreter on there, please.
Good morning, Your Honor. The Spanish interpreter is on the line.
Thank you very much. Will you raise your right hand? Swear that you state your name, please.
Aymara Liste Gonzalez, certified court interpreter.
Okay, are you qualified and been accepted as an interpreter of the courts of Commonwealth of Kentucky?
I am, Your Honor.
Will you give a pledge to truthfully transfer everything that happens to this court today?
I do, Your Honor.
Thank you very much. I'll call the case of Kelvin Rodriguez Riviera.
Vamos a convocar la causa de Kelvin Rodríguez Riviera.
It's 23 CR 0047
23 CR 0047
for probation revocation.
para revocarle la libertad vigilada.
And 26 CR 0052 for pretrial conference.
Y 26 CR 0052 para una vista preparatoria.
Are you Kelvin Rodriguez Riviera? Sir?
¿Usted es Kelvin Rodríguez Riviera? Yes.
Were you born in 1989?
¿Usted nació en 1989? Yes.
Are the last 4 digits of your social security number 6235?
Los últimos números de su seguridad social son 1632.
6235.
6235.
Correct. What does the Commonwealth have to say?
Your Honor, this is,
You need to get up here so she.
he has a 5-year sentence on the previous one, endangerment.
Okay,
We
wait
picked up.
a second.
Oh, I'm sorry.
Okay, you go ahead, just get there and speak slowly.
His pending case is wanting endangerment 5 years.
Él tiene un cargo o caso pendiente por imprudencia temeraria con sentencia de 5 años.
He has a new case, assault third.
Tiene un nuevo caso por agresión física en 3er grado.
Mr. Cross is claiming a medical disability that caused that.
El señor Kraus dice que tiene una discapacidad médica que le ha causado eso.
He furnished me medical records from Cookville Hospital this morning.
Y me dio los registros o historia clínica de un hospital en la mañana de hoy.
Unless they change my mind, I would ask that the court set this trial next month. I'd ask for one more month so I can review.
Yeah,
Le pido-
go ahead.
Le pido un mes más porque a menos que los registros médicos me hagan cambiar de idea, le pido a su señoría que lo concerte para juicio de aquí a un mes.
We have a negotiation day on August the 3rd.
Tenemos fecha de negociación el 3 de agosto.
And the next court date is on August the 6th.
La próxima comparecencia al juzgado es el 6 de agosto.
If we don't reach a resolution on that date, we'll set a speedy trial.
Si no conseguimos un acuerdo ese día, lo fijamos para un juicio sin demora.
Mr. Rivera, your attorney is here today and he'll be down to see you at some juncture.
Señor Rivera, su abogado se encuentra en el día de hoy aquí y él irá a verlo en algún momento.
Okay, thank you very much. We
Muchas
have
gracias.
the interpreter today.
No.
Jim, thank you for being here. You may be released.
Thank you, Your Honor. Thank you.
Commonwealth versus Archie Boykin, Clinton County. Archie Boykin. Are you Archie Boykin?
Yes, sir.
Morning. We're here on 26 CR 0031 for a pretrial conference and 24 CR 0061 for probation revocation. Mr. Boykin, were you born in 1976?
Yes, sir.
Are the last four digits of your social security number 8005?
Yes, sir.
What does the Commonwealth have to say?
We need a trial date on the new case now.
What is the case about?
It's a possession, I believe.
You made an offer on a possession case?
The problem is he's got a lot of time, 10 years or 12.
He's got 10 years. We've had misdemeanors, a couple misdemeanors on probation. Now he's got a felony, so I'm just gonna try it.
Okay, that's fine.
There's a lot more writing on this possession case than most.
How much time? Are you ready?
We have some records we need to gather. It's gonna be a fairly short and simple trial, but there is some preparation that I need. I would ask for sometime, we've got sometime into August.
Okay. What about August 7th?
Judge, I've got a football game
Okay.
that afternoon. I hate
It's
to
too hot
miss.
to play football in August.
I agree, but
I
we're
get you
doing,
out of it too, I guess.
I just hate to miss any of my son's
I got you.
football games.
Yeah,
That goes on, that judge, that goes for every Friday in August.
Wayne County on the 26th, August, what is that? What time do I have to school? Do you have court here on August 25th? Oh, 26th.
That's right.
25th, open. How about August 25th?
That'll work, Judge. All right, y'all be in touch.
All right, thank you. Can I go now?
Yeah, thank you.
Thank you, man.
Terry Britt. Terry Britt. Come over, is Terry Britt. Are you Terry Britt?
Yes, sir.
Good morning. This is 26CR0048. Mr. Britt, were you born in 1995?
Yes, sir.
Last four digits of your social security number 7633.
Yes, sir.
Hey, you're here on a pretrial conference. What does the Commonwealth have to say?
Judge, Mr. Brett is a co-defendant to Mr. Ledbetter, who we saw earlier in the docket. I will be keeping Mr. Brett's case. We will be getting counsel for Mr. Ledbetter.
That was 28th and 10th.
No, I think we set those over for August, although it will,
August 3rd and 6th.
yeah.
August 3rd and 6th. And negotiation day on August the 3rd. Next court date on August the 6th. If we don't have an agreement, you and your co-defendant can see the file. Your attorney will be over there. This picks you up a month, makes things resolved for you, little singer, okay?
All right.
Okay, thank you very much.
Thank you.
Jack Brown. Commonwealth versus Jack Brown. Are you Jack Brown? Good morning. This is 26CR0018. Mr. Brown, were you born in 1992?
Yes, sir.
Last four digits, social security number 4108.
Yes, sir.
We're here on a pretrial diversion application. What does the Commonwealth have to say?
He's got a possession, controlled substance, first degree, 3 years. On a pretrial diversion, he's failed to attend SAP IOP, failed to report to SSC. May the 14th, used meth, denied, but the lab confirmed. Then he failed to report on June the 2nd of 2026.
Judge, he's certainly gotten off to a tough start with probation. He hasn't been on very long at all. I had talked to Jack about possible drug court. He's in agreement to do that. Our only concern is whether transportation will be an issue for him. He does live out in the county. And right now his license is suspended. Obviously that stuff eases up as you get into the program. You develop relationships and rides, and maybe the license issue resolves itself at some point. But would you be willing to look at it for drug court?
Well, he would certainly have to be a lot more diligent than he's been on probation in order to even have a chance of drug
I
court.
don't know whether I've seen anybody for a while, just totally disregard.
I think maybe I would ask that his diversion be revoked and maybe considered it probation.
Yeah, I'll tell you. I'm gonna revoke the pretrial diversion, and then as soon as he's eligible for shock probation, we'll take a look at shock probation. Between then and now, give him an opportunity to set up transportation and maybe put him out in drug court after we shock probation. He's willing. Jack, I hope you make an effort if we give you a break on the shock probation here in a little while to do better than you've done. You understand what I'm saying? Jack, can you hear me?
Yeah, I can hear you.
Okay, so I'm gonna revoke your pretrial diversion, but we're gonna take a look at shock probation. They said that transportation was gonna be a problem for you if we put you in drug court. Are you willing to try drug court?
Yes, sir.
Okay, so what we'll do is between now and the time that we get you eligible for shock probation, you need to make arrangements with your attorney to see if you can get transportation to the drug court, and we'll give you a try, okay?
Okay.
Okay. Thank you.
We're gonna see him on the 6th for sentencing.
Yeah, the 6th. Sentencing will be on the 6th.
Thank you.
August the 6th, yeah. Stanley Catherine. Are you Stanley Catherine?
Yes, John.
Good morning.
Good morning.
21CR0097 for revocation, 21CR00120 for revocation, 21CR0084 for revocation, and 26 CR 0053 for a pretrial conference. What does the Commonwealth have to say? This is Mr. Catherine was born in 1982 and last four digits social security number 1354. Is that right, Mr. Catherine?
Yes, Your Honor.
Go ahead.
Your Honor, he, on the three cases that he's on probation for, he has a total of 7.5 years to serve. He's charged on a new case. It's not a standard probation violation. He's charged with a new felony use of electronic means to send pictures to a person posing as a minor. So I've made an offer on the new case. If he's not going to accept, I guess, or make a counter offer, we need to get a trial date.
Judge, Commonwealth's not made an unfair offer, but I feel we need to do some investigation because it is a little bit of an irregular situation. This the vigilante group who does this kind of thing and does their own investigation and then hands it over to local authorities. So I need to do some research into this group and how credible they are and if they've done this before, if their cases have been prosecuted before.
We surely wouldn't want to deal with people who make it a habit of trying to expose people or exploiting children. We surely wouldn't want to deal with anything like that. You want some more time?
If he wants some more time, as long as he's in custody with the whole, that's
It
fine.
will be, let's set this for August the 28th and September the 10th. August 28th negotiation and September the 10th, okay? The attorney will be over this, wants to do more investigation, Mr. Catherine, before he takes an action. He'll be over to see you, okay? Thank you very much. Commonwealth versus Casey Fortin. Casey Fortin. This is 26 CR 0024. Are you Casey Fortin?
Yes, sir.
You born in good morning. Were you born in 1991 and the last 4 digits of your social security number 7645?
Yes.
Okay. What do you have, Mr. Stockton?
This is a motion to revoke pretrial diversion and the
You
incident.
need to get over behind the mic.
I'm gonna call Mr. Payne and just let him testify. He can explain this one. It happened on June the 2nd of 2026.
Okay, you raise your right hand. Swear the testimony about to give us your full total truth, nothing but the truth.
Yes, sir.
Go ahead.
Mr. Payne has been trying to attempt to supervise Mr. Ford. And he has a 3-year sentence on possession of controlled substance.
Yes, sir.
Can you tell the court what happened on June the 2nd?
On June 2nd, client reported probation and parole. Client advised he drove himself to probation and parole on that day. Client was asked if he had a valid driver's license and he said he did not. Client was advised by phone text on May the 20th, 2026, not to be driving without a valid license. And that he stated he understood, but he had to do what he had to do. And then he was advised again not to be driving without a license, without his license active. Then he come into my office on June the 2nd. Client was placed into custody and served with a FTA warrant from Pulaski County. Once he was placed into custody, he was very aggravated with this officer. Client stated, make me lose my job. I'm going to F this place up. Then client was asked if he was married and he advised, I told you on the paper I filled out. Then when client was advised it was time to be transported, he stood up and walked and was advised to stop. And I kept telling client to stop and he kept walking. Client was told again to stop and then he had to be stopped and detained by Officer Farrell. And he pulled away from Officer Farrell and kept trying to walk towards the door. Client was very disrespectful with officers as they were trying to place him into the car to lodge him.
Well, I understand this. He was going into custody from an FTA from Pulaski County.
Yes.
Even before you obtained the warrant on the license.
Yes, but I was placing a detainer on that date also because he told me that he drove to the office and I think he quoted and said he didn't have a mommy and daddy to take him to work. So if he was going to get to court, he was going to drive and I couldn't let somebody leave my office driving and get out here and hit and kill somebody and it come back on me and with me knowing they didn't have a driver's license.
You don't have any more questions.
You have any inquiry?
I have an inquiry on that.
Okay, be excused. You have any other proof of Commonwealth?
No,
Judge, he's been in custody since June the 2nd. He did report that day, even though he drove without a license to the court site. You know, Casey has kind of gotten in this, you know, system where he can't get to work without driving, he can't get to court without driving, he can't get to probation pro without driving, and none of those places are next door to him. I've advised to, when he gets out, he needs to probably locate himself closer to work, closer to probation, so that it's not such a struggle for him where he has to drive. I would suggest that the time that he has in, which is about 35 days, is a sufficient sanction for him to be released back out. Obviously, no driving, no violation of the law as it has been all along.
I think 35 days would be appropriate sanction for driving without a license, but I don't know if that's enough for that. I mean, these officers have a job to do and they're not out looking for trouble. And all he was wanting to do is be disruptive and get mad at them because they're doing their jobs. So I don't know what can change that other than jail time.
Well, I'm gonna revoke the pre-trial diversion. This shows there and take a look at shock probation. And as part of that, I want him to be assessed for anger issues. And see if we need to get an anger management situation. I will even revisit revocation of pretrial diversion if I'm convinced, and the Commonwealth can be convinced, that Casey Ford can conform. It appears that he's been trying to work. Okay. I tell you what, I'm just gonna I'm not gonna revoke a pretrial diversion today. Okay. What I'm gonna do is let him be assessed for anger situation. Casey, you know, I give anybody a break that I can. I don't want to send anybody to penitentiary. It appears that you want to work, but you can't be treating these officers like that. You know, and you might have you might have been having a bad day or anything, but you could get hurt. I mean, some of these people will hurt you. I mean, or you could hurt one of them and you get a long time. So I'm gonna ask him to be assessed for anger management and everything. And we'll take another look at him on August the 6th. Okay,
He's to remain in custody.
remain in custody till then.
Does probation and pro have a way to make that happen?
I think you'll probably need to do that. I don't think we
I'm
have.
not sure we can get him assessed. I don't know whether the jail could take him to Adonta or something like that.
Well, if you can get Adonta to take him, I'll enter an order for somebody, if the jail here can take him, it's a short drive to Adonta. Okay. And if you go out there, Casey, you need to be honest with those people if you got some stuff. All of us have time periods in our life where things aren't going well and crashes on us and all that kind of thing. But you gotta get a hold of yourself, man. And dig yourself out of this hole, okay? We'll take a look at it on the 6th. Thank you. Edward Mangbeer. Edward, could you give me a pronunciation of your last name?
Minehair.
Minehair, okay, thank you. Edward Minehair, 26 CR 0057. Sir, you born in 1959?
Yes.
Last 4 digits of social security, number 6147.
Yes.
Now, you're here for the purpose of arraignment. Your attorney is here. You have a right to remain silent. I suggest you do that. I'm gonna read the charges just to make sure you understand what the charges are, okay? You're charged with criminal attempt to commit murder, unlawful imprisonment in the first degree, assault in the first degree, wanton endangerment in the first degree, 2 counts, terroristic threat in the second degree, public intoxication, disorderly conduct in the first degree, criminal trespass in a third degree, resisting arrest, and menacing. You understand what those charges are? You understand what the charges are? I'm not asking if you did anything. You understand what I just said to you?
I think I understand some of it, yes. I've never been arrested.
Well, you'll get an opportunity. You don't need to say anything. You understand the charges you're charged with, correct?
Yes,
Okay. I'm signing a reciprocal, you represent counsel, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, I do,
I'm
Judge.
signing a reciprocal discovery order here that requires the Commonwealth to provide you with information to help your attorney prepare your case. Mr. Stockton, how complicated will discovery be things in this?
I don't think it'll be complicated. It'll take a little bit of time to get it done. I've got a motion filed to get medical records from the victim from UT Medical Center in Knoxville. I don't think there's an objection, is there?
No objection.
Okay, I'll enter that. Let's just go out to August the 28th for negotiation day.
Yeah. The Defense counsel made a request to get an item tested. I don't know how long that'll take, but we'll go ahead and get that
Well,
started.
let's say August the 28th for negotiation day and September 10th. And if we have any forensic evidence problems between then, y'all can do an agreed order and push it on out. August 28th, September the 10th. Okay?
Thank you.
Your attorney will be down to talk to you, sir. Thank you.
Thank you.
Lucian Stevens. Lucian Stevens. Are you Lucian Stevens?
yes, Your Honor.
Good morning. You're here on 23 CR 0032 and 26 CR 0051. Mr. Stevens, were you born in 1996?
Yes,
Last four digits, social security number 5171.
yes.
That's a Commonwealth have to say.
This is a motion to revoke pretrial diversion in 23 CR 32. And then he has a new charge of wanton endangerment and DUI, and I've made an offer in that case.
And Judge, we are in receipt of the offer. I've talked to Lucian about it. There's not a lot of room on this one. Go. If we set it over for our August date, I think we'll either have
August
a
the
resolution
3rd
or.
For last negotiation, August the 6th. If we don't reach agreement on that date, we'll set a speedy trial. Your attorney will be down to talk to you, Lucian. Next case, Mitchell Thrasher. Commonwealth versus Mitchell Thrasher. Are you Mitchell Thrasher?
Yes, sir.
Good morning. This is 25 CR 0084 and 26 CR 0055. Mr. Thrasher, you born in 1964.
Yes, sir.
Last four digits of social security number 3055. Social security number, last four digits 3055.
Yes, sir.
We're here for arraignment on that second charge. You have the right to remain silent. The grand jury of Clinton County's returning an indictment charging possession of controlled substance, the first degree methamphetamine, and possession of drug paraphernalia. You understand what the charges are?
You understand?
Approach the identity of the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions.
Yes, Judge.
Sign reciprocal discovery order here that requires the Commonwealth to provide Mr. Thrasher information necessary to help him prepare for his defense. And what do you have to say in this from Mr. Stock?
Well, we need a negotiation, see if we can wrap up those cases since he's just now been arraigned on the case.
August the 3rd at 9 a.m. for negotiation day and August the 6th for the next court date. That's pretty speedy for you, Mr. Thrasher.
Judge, I wanted to,
So your attorney will be down to talk to you. You have something?
I wanted to address bond quickly. Mr. Thrasher is undergoing care for a cancer diagnosis. He's going to chemo treatment from Bowling Green jail, it's taking him back and forth. The way this new case arose, my understanding is he had missed court here for the 25 CR 84. He was actually, I have some documentation that he was actually at the medical center. Receiving treatment.
What's his bond now?
In 25 CR 84 is a criminal law in 26 CR 55
I'll go with 15,000, clerk approved, sure.
Yeah, he's, the problem I'd have is, and I think maybe we can get him into a rehab over near where he's getting his treatment. But I don't want him out here using drugs while he's getting his cancer treatment. That's the problem I'm himself. He's kind of.
I don't want to either, but if I was taking cancer treatment, I might have a different attitude about that.
That's true.
You know,
I
Mr.
just think he's
Thrasher,
right where he needs to be.
we're gonna put you on, the Commonwealth has acknowledged, they understand that you're in a difficult situation. Here's the thing about it. I'm gonna let somebody come in and sign a clerk approved surety. But you're gonna have to stay at home, go to church or the doctor and stay at home. And don't be taking these illegal drugs. If you've got, don't be self-medicating. If you've got a problem with pain or depression or anything like that, you need to go to your doctor. Most people that go through cancer treatment have some depression going on, okay? So will you commit to me that you won't be getting on these illegal drugs anymore? You won't get out and be rousing about. Will you do that?
Yes, sir. I'll stay at home.
Okay. You need to get somebody to come in and make a $15,000 surety bond.
What that 50,000?
Both cases.
Okay.
Both cases. Okay, hope your treatment goes well, Mr. Thrasher. Okay. Do we have anybody down there at the jail that's on the docket that we haven't seen?
That is it, Your Honor.
And thank you very much. Does that conclude the criminal docket?
No, other than correctional institutions haven't been online that the grand jury's rated.
Well, I don't know whether we have the hearing. Roller facility.
I'm gonna do a transport order for Mr. Purdue to be brought, because I don't think they're gonna do that.
I received some kind of fax note from the clerk's office, and I honestly, I couldn't read the email address that was on it, but
We all clear this out over here and we'll bring the grand
I put
jury.
the fax, it said that they would appear by then, and I put the fax number on the distribution, I could read the fax number.
I'm just gonna submit a transport order.
Mickey Sheldon, there's nothing to report on him because they didn't transport him down to negotiations, so.
Let's just do transport orders on all three of those for the next
That's
quarter.
what needs to be done.
Okay. Are all those yours? One of them is Samantha.
Two of them are mine, one of them is Samantha.
Well, you
That's
have-
already our plan, I think.
Okay, if y'all will go ahead and do those transportation orders, it'll be a good thing. We'll let them ride down here if they don't want to get on soon. It's a beautiful time of year. Bring the grand jury, please.
Our son, the chair was on. Democrat issues or something. Yeah.
All rise for the grand jury, please. Everybody can be seated. Who is the foreperson of the grand jury? Okay, you'll stand there just for a second. Have 9 or more of you agreed on the document that you have there.
Yes, sir.
Would you present it to the bailiff and you can have it. I'll see you the top. You can bring the vote. What she said.
Thank you, sir.
Okay, it appears that everything is in order here, ladies and gentlemen. I'm going to sign the document that will initiate the process. If any of these individuals are already in custody, we'll probably do a summons on them. If they're already in custody, if they're not in custody, we'll issue a warrant. And they'll be picked up in a bond sufficient to assure their attendance will be here, or if there's a situation where they might pose a danger, we will put a bond sufficient to make sure that the public is protected. It's very crucial for you to keep confidential anything that you get back there in the grand jury room, because people might decide to flee or might, so, that sort of thing. It might be some sort of problem. Are we just now back on the record? Okay. Okay, so I guess the next time that we'll see you is on August the 6th, that you'll be here unless you call back in, but for emergency or any kind of insurrection. And these days, you can't ever tell when there might be an insurrection, even coming from Clinton County. Not likely, but until that, you're free to go on, be back here on August the 6th. All rise, we will your time.
Yeah.
Okay, let's go on. Does that conclude the business of the Clinton Circuit Court Criminal Division? Mr. Stockton, are we finished?
We are.
Okay, then we are in recess until 1 o'clock. Lower versus lower.
Judge, there's an agreed order in that case that has been submitted, Your Honor.
Okay, thank you. Then electronically filed, I guess.
Yes, sir.
Cabinet versus Muse.
Same in that case, Your Honor.
Brewington versus Brewington.
I think Mr. Brewington, sir.
Are you James Earl Brewington?
I'll get that second.
Yeah. Go ahead.
Yes.
Okay, what do you have?
Judge, think we have an agreement in this. The non-custodial parent, Mr. Brewington, said he could pay 1,000 by August 5th, and that's an order that was submitted, Your Honor.
Okay. Okay. Keep in contact with him, see where you are all the time. Okay. Huddleston versus Gladwell.
Judge, this is a motion to establish child support, so probably need to let Stephanie.
Raise your right hand, you swear the testimony about to give is the truth, the whole truth.
I do.
State your name, please.
Stephanie Witham,
May proceed.
Ms. Witham, by whom are you employed?
Clinton County Child Support,
And what is your position?
caseworker.
Are you familiar with the case we're hearing today involving Huddleston versus Bob?
Yes,
And what is your involvement in this case?
I'm the caseworker.
Okay, and how many children are involved?
2 children.
Okay, and did you run a calculation to figure your child support amount in this case?
Yes,
And was that based upon the taking child support guidelines?
yes.
And what did that amount come out to be?
We're asking for $291 per month effective July 1st.
Is that based on minimum wage?
Yes,
That's what Dusty's gonna pay.
yes.
Yes, sir.
He's properly before the court.
He was served May the 2nd.
Has he been in contact with y'all at all?
No,
Okay, just submit the order.
I think that's all we have today,
Okay.
Judge.
That's good. We don't have anything. We have a DVO docket at 1:15. Are the parties here? Okay. Yeah, we'll just handle that one all. We call this a civil motion. They have a civil motion on too, so we'll combine them in here when we call it through the docket. So we're 5 minutes out, I guess. For if anybody that's both parties here that want to go out of order, Harden versus Harden. Well, it's 1:30. I thought it was 1:15. Okay, well, let's go into recess till 1:30. Everybody have a seat, please. Let's start that. Harden versus Harden. It's Harden.
Judge, I've actually spoke with Sheriff Markham right before I came into court. I've learned that Miss Harden got arrested last night for hindering prosecution and theft while the children were with her.
Where are the children you have now? Well, we'll just pass over this.
Judge, I would ask, could we put some kind of temporary order in place until we come back to court? Because we were here in May. Since then, she's been arrested twice in the last 2 weeks. One of them was for one of the
Let's
individuals.
just restrict that. Just come back earlier next month. Just go ahead and put a restriction on her visitation until she's able to come back in.
All right, I'll submit an order. Thank you, Judge.
Now, we probably should be something in the order about her communication. That she can communicate with the children by phone and that sort of thing.
All right, I'll do that, Judge.
Okay.
Thank you.
Thank you. People's Trust at Pickett County. This is a motion for distribution of funds.
Yes, Joe, this is Joe Staten. He's one of the heirs. We have no objections to the Master Commissioner's proposed order that Holly sent. We got a copy of it yesterday evening. I assume it's in the file.
I haven't seen it, if it was in the file yesterday afternoon.
Correct, that's what it's, we got it in there.
There are no unpaid debts or anything else, just a flat distribution or.
That's all we understand because people's already received their funds many years ago. So it's a 2021 case, so I'm sure they received their funds.
2023 case, isn't it? Yeah, 21 case, isn't it? Yeah.
Yes. Yeah.
Wonder what's the holdup on distribution of funds?
I don't know, but Joe hired me and his brother when their mother passed
Was it
away.
the previous commissioner?
It was.
Yes.
That's probably what they got swapped over.
Yeah, okay. Okay, if you
No, no, no.
electronically submit the order, did you? Holly's order is fine then?
It's
Okay,
efficient with us.
okay, it'll be fine, it'll be,
Thank you.
thank you very much. Yeah.
Joe. See you.
Yep.
Moons versus Moons.
Judge Ralph Gibson on Zoom appearing for Ms. Moons.
Okay. Moon versus Moons. This is your motion,
Yes, Judge.
Ms. Capps.
Judge, I had filed a motion asking for some additional time in the summer for my client, just to modify the timeshare based on that. And to see if we could maybe mediate it, if we could not address timeshare for the summer in a hearing. My client had asked me to request possibly a visit with his child for extended break, July the 19th through the 24th and August the 7th through the 19th. I think she's got professional development days, August the 10th through the 19th.
Mr. Gibson, what do you have to say?
Judge, that's the first I've heard of the additional request. The only motions I have in is that she wanted to modify it from week to week in the summertime, and we would object to that. The reason.
It would take a significant change in circumstances for me to do a modification at this early date. So there's not going to be a modification done on week to week because we spent years on this thing and a long opinion and everything. So we're not going to do that now. let's get down to some specifics that.
Judge, I think I moved to modify only the summertime share.
I know, but I'm not gonna summer, winter, whatever. We've spent a whole lot of time on this and I'm not gonna start piecemeal and be up here every month doing that. It's not gonna happen. Okay. Now, is there any specific things that could be agreed upon? You probably need to go back in the room there and get, Mr. Gibson on the phone, talk about it, and I'll call it back up.
I will. I did actually email Mr. Gibson and asked him about if we could agree to 2 additional weeks, then we would withdraw our motion, but I didn't get a response from that.
Yeah, we didn't agree to that, Judge.
Okay, we'll go back there and see if there's some modifications and the parties will stay out here and the lawyers will talk. Mr. Moons, you stay close to your attorney, and then Mr. Gibson, your client, you have your phone with you. Do you have Mr. Gibson?
If she feels comfortable, I don't care if just me and her and she calls Mr. Gibson if
That'd
that,
be fine. She'll need to talk to him first.
yes, that's fine.
Okay, if y'all can use one of the rooms back there, we'll call the case back up. Okay,
Thank you.
yeah. Owens versus the medical center at Clinton County.
Good afternoon, Your Honor.
Hello.
Brianna Berry for the defendants.
Yeah. Okay, now the only issue that we have now is disclosure of the documents that I reviewed in camera. Is that correct? Is that, you have any other issue, a discovery issue?
I have filed a separate motion on some other discovery, but if that issue was resolved, it would probably resolve the one that I have recently filed.
I kind of read it that way. I didn't know whether we were talking about something else. I will tell you that I reviewed the case law that y'all put. I reviewed this, these things that were in camera. And it's not very enlightening to me on what's discoverable and what isn't discoverable. So let's refer to these 2 documents I have. One is an instant report, I guess.
Correct.
Is that correct?
It's
And what
instant
would you
report.
refer to the other?
I believe it's the fall puddle report. It's the title of the other.
I believe that's correct, Judge.
This was the instant report and the other one was what?
A fall puddle report?
Huddle.
Huddle.
Huddle. Like
Oh,
Huddle
when they got
House.
everybody together. Well, I read it and I thought maybe that was. Now, I really don't, I looked at this stuff. It seems to me that the incident report is discoverable. To me, are there certain portions of the incident report that you find particularly objectionable? I mean, how does anybody find out what happened if they don't have access to an incident report, or how can they judge the credibility of the witnesses who later come forward under deposition and say what happened to see if it's different from what they initially put in the incident?
Yes, Your Honor, I believe in this particular case, what should have happened and what actually happened is kind of the difference there. So what should have happened is that the assessments and the first evaluation of Mr. Owens after the fall should have been documented in the medical record.
I did, and it wasn't there, and they found, they heard him fall. He was in the room by himself,
Correct,
and they heard him fall.
correct.
The wife had gone out to get some coffee or something. His wife had been with him and she wasn't there. So the nurse had responded and put him back in the bed.
Correct.
Yeah, I don't see anything since we, I don't see how you can keep that from being discoverable. So, I've looked at it and it appears to me that it wasn't done for any purpose of keeping that sort of activity from happening. That's really the theory behind the protection on some of these things, is they don't want to keep an honest assessment of remediation for things that happen for future problem. That's the theory behind it. And I'm going to rule it that. Now let's talk about the Huddle report, which I find to be a little different in a way.
Yes.
Now, the reason that the Huddle report might not be discoverable is because you want to have these folks all being candid with each other about assessing what this person, that person done. And they might be expressing opinion that they would refrain from doing if that sort of thing was discoverable. I understand that. Is that a good background for what those things are going to do?
Yes, Your Honor.
Mr. Carroll, with all due respect, I'm gonna hold that huddle report out right now, and I'm gonna let you look at the other, and then once you look at this other report, if it doesn't answer all the fact situations you have, then we can set another hearing on this and take some testimony on it. And that's what my ruling is gonna be. Now, I don't do a lot of these sort of cases, and we don't have a lot of these sort of cases done here. But
I think that's reasonable, Your Honor. I'm not going to object to that.
but I'd rather be in hell with my back broken after read those cases.
Same.
Because well, here's the thing about it. If you don't do this kind of work frequently, and I never did, the acronyms and the different things like that make me have to go back, like I say, Uniform Commercial Code. Professor Leibson says you need to spend all your time back in the glossary, in the definitional section, to make sure you understand. So that's what I'm gonna rule. If you'll draft an order and circulate.
I'll draft an order.
And that's all you need right now?
That's all I need right
You
now.
don't need anything else right now?
No, just with the production of the incident report, will your motion to compel be held in
It
abeyance?
will be, or I'll remand it.
Okay.
Yeah, and he'll take a look at that. We'll be all right, okay? And I'll make sure that, what's been sent here remains under seal. And you,
Yes.
of course, you need to have a confidentiality statement in your order, right? That you'll keep confidential,
I'll put that in order,
okay,
Judge.
thank you very much.
All right,
All right,
thank you.
thank you. I believe that's all I had, Your Honor.
Okay, we'll have a safe trip. Okay, York versus Albertson versus State Farm Mutual Insurance.
Judge, this is my motion. Darren Banks here for State Farm. This was a case that the plaintiff filed, or you probably had a chance to look at it over
Now,
sorry.
let me just see if I can get down a short thing. You had multiple people in the household that had different liability insurance that this one.
Well, there were three policies in the household.
Yeah.
The parents owned three cars,
Two 50-hundreds and one 25-50.
two 25-50s, one 50-hundred.
Yeah, I knew, but the car that was involved in it had
25-50.
25-50. Now, I kind of believe that you said that one of them that had the 25-50 was one that was designated to be driven by the person that was in the accident. Is that correct?
I'm not sure whether they were designated, but they were certainly the person operating. The person that was operating the car in the accident, that car had a $25,000/$50,000 policy.
So you're saying if any of the members of the household had driven that car, it'd be 25?
Yeah, the only policy limits
See,
on
a
the
lot of
car.
times, I've seen, not that people do it, but if they have a child in the household, they'll have a 25-50 on the
They kinda
child.
move
They'll
it.
have 100, 200, or 500 in that.
Yeah, they move it around.
Yeah.
But in this situation, this policy is a very specific policy, insures one car, and that car has that limit, and that is the only coverage that's available for
Now,
that car.
if that young lady that was driving the vehicle was driving a stranger's car.
That car,
50-hundred.
well, for a reason.
Well, that car been primary.
That's right. That's the big difference.
Yeah.
I thought it
The
applied,
car she was driving been primary,
right,
and then they would come back
to the excess coverage.
excess coverage, which could be 1,500.
Yes, right. And that's the big difference
That's
because,
what Mr. Garmin says doesn't seem right.
That's right.
well, it doesn't sound right because there's a difference between primary coverage, which the law says follows the car you're in,
I understand.
and excess coverage. And if that were this situation, they would have it. It's just not this situation. She's driving a car that she paid a premium for 25,000. If you look at it a different way,
They pay. That's
well,
right.
the insurers pay a premium for that particular coverage. Had they wanted more, they would have paid more. If you took his approach and you had three cars insured, you could insure one for 25,000, insure five for, or you can insure one
Well,
for.
we're talking about liability insurance. So
That's right.
I
But
mean,
you
it's always insure different vehicles for, regular coverage on the vehicle for different amounts based upon how much the car is worth, right?
Well, on property,
Yeah.
but on
I
liability,
understand.
yeah, on liability,
Or underinsured.
underinsured, you can buy different coverages,
Yeah,
but that coverage is something you're paying for. In this situation, whereas underinsured is personal, it's
I
the person.
understand that.
Yeah.
I just want to set the thing up so let Ms. Garland
Well-
give me some unique argument. Okay. when you get where you're not all right, I'll go like this. Okay, tell me, Mr. Garment, I didn't see any law you had, except you just didn't think that seemed right.
Judge, that's right. I mean, the law is that, any ambiguities resolved in favor of the insured. And essentially, my argument was, and obviously your honor's read the briefs and very familiar with the situation, that the other
Well, I wasn't
liability.
completely familiar because I thought this was the main policy on this person. It wasn't, so.
Correct. I just feel like the fact that there was the other liability coverage section of the policy, is enough of an ambiguity.
Well, why would you ever insure one for less then? If there wasn't a difference between the coverage you had on each vehicle, why would anybody ever insure one of them for, I mean, you could have $150,000, $100,000 property and insure the other vehicles with liability insurance for $25.50. Save money that way. But when it came to for the secondary coverage, they'd always go to the highest policy.
Yeah, I
That
think
would be a problem, wouldn't it?
I agree with you, Judge. I think the issue here and what makes this a little bit different to me is the fact that she's underage. None of these policies are in her name. They're all in her, all three of the policies are into the same named insured. She just happened to be driving the one with the $25.50.
I'm sure she was listed as a driver on the policy.
And she is a resident relative, which is part of the definition.
She's a resident relative, yeah, but she's a relative, excuse me, resident relative for all three of the vehicles.
Yeah.
Not just exclusive to Mercedes.
Okay. I just can't see how I can go to the other policy. I want to go to the other policy, but I can see your argument as far as the equity of the situation, but I don't, if you give me any more specific law other than that ambiguity thing, because your argument's so ambiguous.
Yeah.
Okay.
And
Is there any
Judge,
other issue you have?
I'm sorry.
Is there any other issue in this case?
No, Your Honor.
You'll draft an order on the thing and circulate it to Mr. Garman, and then if I'm wrong, my bosses can tell me I'm wrong,
And I'll go ahead and make it final appealable, and if it doesn't appeal, then the whole case can get resolved, because I think that's.
Yeah, they've already offered the limits on
Okay.
the policy that.
That'd be fine. I'll be glad to sign it. Thank you very much.
Thank you.
Okay, Philip Dablo versus Kimberly Sheffield. Okay. Okay. Okay, I got a set of proposed instructions last night that we weren't aware of. The original order said that the instructions should be done by July 1st. They came in on the 8th. It's really like, what? If you had an opportunity to look at his tendered instructions.
I was able to look at the tendered instructions earlier today, Your Honor. I'd filed my instructions as well as a pretrial compliance witness and exhibit lists. I received the jury instructions from Mr. Wilkerson. I saw those in my email this morning where those have been filed. If the court will recall, this matter has been before the court and we have mutually agreed to put it off the past couple motion hours and bring it before the court today. Mr. Wilkerson had previously asked for a trial date on the matter.
That's correct, Your Honor.
Mr. Wilkerson did include an instruction for punitive damages in his instructions, which I did not include in mine. I will probably be filing a motion with the court before the trial to exclude punitive damages in the matter.
You have all this discovery you need now?
The only thing that I think I might need, Your Honor, and I was speaking with Mr. Wilkerson before we came up about this. I don't think that, I'm the second attorney for my client. I don't think her first attorney ever requested any of the documents related to the plaintiff's bankruptcy. And I've informed Mr. Wilkerson that I would like to have those documents to see how, because if the court will recall, this property went into foreclosure, was sold by the master commissioner of this court. And subsequently to that, the plaintiff did file bankruptcy and included the debt related to this in the bankruptcy. So I'd like to review those documents. I think it could pertain to the damages he can claim at trial.
Judge, I would say, from the plaintiff side of things, we are ready to go. This
What
makes
about
our,
the bankruptcy information? You
well,
have-
Judge, I mean, to the degree that Mr. Ramsey makes the request to produce those documents, we would be most likely objecting to the production of that, as the bankruptcy proceedings are of little consequence to the cause of action that we're here for. This is not a debtor. This is, Mr. Dayblow is playing the role of plaintiff and creditor in this case. And so to the degree that Mr. Dayblow filed bankruptcy.
Take them back in the room someplace. Y'all need to go back in the room someplace. You're keying the microphones.
It would just,
Give me a fact situation, again, refresh me on this.
Judge, the facts here are that this house out on 127 headed towards the dam was purchased back in 2022 by Mr. Dayblow from defendant Ms. Sheffield. That's an established fact. And part of that transaction, there would have been seller's disclosure forms and statements made by the seller, the defendant in this case, about the condition of the property, about the repairs.
In particular, what's the problem?
Well, the particular problem was that that it was alleged and stated to the plaintiff by way of seller's disclosures and other just
Tell me
statements.
what the problem is.
The problem is that the house is inundated with water at any given time. That there is significant mold, significant wood rot. The water intrusion is just, it comes, this is a in-ground home. It was purported that the ground floor had been sealed and repaired and that there hadn't been leaks for 7 years prior to the purchase. We've taken discovery, we've got reports issued by water mitigation folks who say that it just simply could not have been the case.
Your Honor, the house was purchased.
Your client received a full purchase price.
My client received full purchase price at
The
closing.
reason I was asking is it didn't have a lien or mortgage or anything in favor of your client.
There was no mortgage in favor of my client. No, my client received the full purchase price, less any sort of commissions. There were realtors involved on both sides, and my client completed the
The realtors
required
are not
disclosure.
named as parties here.
They were not.
Wow.
Well, the realtors, this was the statements were being made by Ms. Sheffield, had been, and that the plaintiff has chosen to not include the realtors as parties defended in the case.
There was also an inspection done of the home, which we've deposed the inspector. He wasn't named as a party in this either.
I usually see real estate agents, and inspectors and things. Your clients decided not to bring them on, inspector on, I guess, it's injunction.
Your Honor, like I said, I got in this case late. By the time I got the case, I don't think I had the time to include the inspector as a third party defendant.
Now, does your client live in the house now, or it got sold at master commission?
It did get sold by master commissioner. Yes, that is correct, Judge, by separate action in this court.
Is that for the debt that was on the mortgage?
That's right. That's right. He had to move out of the home because of the condition of the property. He was just unable to.
He quit making the payments then.
And then he was unable to afford the payments.
It was a VA loan foreclosed, and it's since been sold to some other individuals who I believe are living there now. I'm not sure.
How much damage do you feel like that your client suffered monetarily? What is?
Well, Judge, with regard to that, we've proffered the instruction regarding compensatory damages. I think that a jury could be instructed to figure out.
I'm not asking you what.
I mean, the actual damages would have been in the neighborhood of $40,000 that he would have had to either.
The difference between the value they paid for it.
That would have been an actually different set. That would be a different valuation. The valuation that would also be provided to them is the difference between the fair market value of the property and the condition that it was actually that it was sold to.
See, that's one thing I didn't see when I just flipped through these instructions. Do you have these
Yes, I do. I mean, not to the dollar amount, Judge, because I mean, at current, you know, we still.
Well, you can't lose value after it's sold. I mean, it
So
appears
just-
to me that's what I'm asking what
Right.
happened. Let me just ask you this question.
Okay.
Mr. Carter. Okay. The defendant sells the house. And we can assume that that's the fair market value on the date that it was sold between a seller and buyer, subject to representations. When you claim that your client had to move out, okay, and they moved out, and it was sold at a master commissioner sale, I will not assume that then the difference would be what it brought to master commissioner sale and what your client paid for it. They didn't have it that long, did they? How long did they have it?
How long did my client
Yeah.
have the home? They would have had it for just 3 to 4 months.
Okay, so we ought to establish what the fair market value and then what the master commissioner sale, and there was a deficiency judgment for at some juncture, but deficiency judgment. So how much did they pay for it?
They paid $245.
Okay, how much did it bring it to master commissioner?
135, I do believe.
So you have $100,000 to argue about. Would you agree with that? Well, I mean, at some juncture, I'm gonna have to come up with what the damages.
Yeah. Well, I think that's what they would argue, but again, Judge, I want to see the bankruptcy paperwork to see what the bankruptcy court, he included that in there and what his repayment plan is for that, how much he's actually out as a result of that versus the difference in what he purchased it for and what it sold for to measure.
I don't understand that because he lost the house.
Well, but there would also be an argument that he voluntarily lost the house instead of trying to mitigate it himself. I don't know if he mitigated his damages
I
here.
mean, I know, but at some juncture, that would be a fact. Whether he lived up to his duty to mitigate.
Right.
Have to be in instructions of some sort, but I have to have some measure of what they claim they lost, and what they're claiming they lost is the difference between what they paid for it, which was fair market value, and what it sold for to master and commissioner sale. Now, the bankruptcy stopped the master, was this
The
what
master
happened?
commissioner sale happened. I don't know what the timeline was. I know during his deposition, he said that he had filed bankruptcy and had included, I'm assuming, the deficiency judgment in there.
Is that true?
So there was a brief stay on the proceedings in foreclosure.
Yeah.
But it was very brief.
So they sold the house, and he was relieved from the deficiency. My point is, let me, I'm just saying.
I'm not his bankruptcy attorney, and so
I know you're not, but you're representing in this case. The issue would be this: if he had the remaining liability to the mortgage, he should not be enriched by amount that was forgiven. Let's say it was a $245,000 house, and the mortgage was $240,000. Okay. And part of it's paid off with the sale, and the rest of it is excused by the bankruptcy. Then it would appear to me that you'd have to prove that there was a value beyond those two figures before you could have anything you could recover.
I agree, Judge.
Good.
Well, I do agree, and I would say that.
That's what you're trying to get to, right?
Basically, yes, we don't want a judgment to be a windfall for him.
Well, I understand. Okay, now what's your argument to that?
The deficiency judgment would have been the precipice for the bankruptcy proceeding, Judge.
And if it was forgiven because the property had been sold previously, it was a deficiency judgment, then anything your client ought to be able to receive on the difference on the fair market value of it on the day of the bankruptcy sale should be reduced by that amount. And what's remaining would be the bankruptcy sale plus minus or plus what was forgiven in the bankruptcy. And then if anything over and above that value was, that you might have a claim if you can prove that these misrepresentations were made. I'm just trying to get down to see what ballpark figure that I could submit to the judge.
Judge, I think that last schematic there with regard to the damages is appropriate under the circumstances, and that's, we're not.
So the proof would be what was the fair market value of that property 3 months after, you know, when the sale took place, and what was I don't see how your client's lost anything. How's your client lost anything except what they might have paid up to the point that the mortgage?
Well, they're still paying off the debt and the
I
mortgage.
thought he got discharged.
I didn't, I said that it did not. I said that
The deficiency didn't get discharged?
the deficiency was the precipice for the bankruptcy proceedings, Judge. I'm not in a position to say today to what degree that was mitigated or worked
Well,
out.
I
So
want you to make disclosure on that now.
okay.
He testified during deposition that he had a payment plan through bankruptcy. I don't know what
For
chapter
the
that is
deficiency.
for. I don't know what all it included. I don't know if it was just for the deficiency on this or if that included consumer debt that he included in the bankruptcy. I don't know what was part of the
Okay, I
bankruptcy.
want, I don't like that you were this late. But it's, I'm gonna let it go. Don't worry about it. It's just, but I'm gonna ask y'all one more time. You give him the discovery about the bankruptcy so they can see what the plan includes, okay? And then I want y'all to sit down and try to agree to some instructions, except I want you to state how you differ. When you differ on an instruction, I want you to argue why you differ on that instruction.
Okay.
Because this could be one that I could easily gum up. And I might also have a staff attorney that takes leave for a while if we start going down to this instruction. Because this has got a lot of complicated factors, you know, the bankruptcy and the claim that it wasn't this and that, and the plan that was paying off and the deficiency wasn't discharged. Okay.
Is the court going to set a deadline for that to be done? Do you want to set another date for?
I want it completed and handed to me 5 days before the next rule day. The next.
Judge, if I can make a suggestion, there was a time at the end of last year that we attempted to try to get a scheduling order in place so that we could get this moving in the direction of trial. Part of that was to get the parties to attempt some sort of mediation. That has, we've just never done that. I would imagine that the court would appreciate us, you know, proffering this discovery and then as well as trying to find some sort of avenue to mediate this claim before we get this complicated instructions to you. If the court could order that, we would certainly be.
Your Honor, I'm never opposed to mediation. However, every time I have mentioned some sort of offer of settlement or mediation or anything to my client, she is adamant that she did not do anything wrong in this situation, which I agree. I don't think she did. And she isn't willing to offer anything. So at this point, I don't know if mediation would be fruitful because I don't know if my client would offer $5 to settle this case.
I want it done that way.
I understand.
Okay, I want you to give that information to him. Let's come up to some realistic approach on how much your client lost in that, so I can put in the instructions anticipating. Now, once we do that, you'll have something to take to your client.
Sure.
See what kind of exposure. Right now, there's nothing to mediate because she's at 0, not thinking that there's been anything lost. She thinks she did everything right. And if your client didn't lose anything, now that might be a jury question. But
Your Honor, the only thing I would ask for the court in setting this, if the court would allow us to go to the September rule date, just for the fact that I have a fairly complex product liability case that is set for a pretrial at the beginning of August.
September the 10th.
I will be out of town on September.
September the 10th, we'll set a trial. And in this court, you don't have to wait long for trials. So as y'all are getting this thing, get any additional discovery, you know, because we come here in September the 10th, we're gonna have a short screening on this thing.
Judge, I'll be out of the country on September 10th. It's my 10th anniversary and Mrs. Ramsey might kill me if I'm not with her.
But I'm not gonna go to October.
Judge, what about Cumberland at the end of August?
I could do Cumberland at the end of August if the court would agree to hear it in Cumberland.
Yeah, I'll agree to Cumberland. Where's my calendar? 23rd.
I'm sorry, 27th. August.
27th of August. Set of blocks. That it. I'm gonna be in Wayne County the day before.
special judge.
Yeah,
August 26th.
yeah,
That'd work for me.
yeah, and it worked for you
It
too.
would save me some mileage as well, Judge. Yeah.
What time do you
Yeah.
want us?
What do I have to think?
It starts at Stevens Street.
Well, how,
It all depends on whether the expert has to report back and ready conflicts. If an expert doesn't have to report on, it will be free for rescheduling.
let's try it at 11,
11 o'clock.
11 Eastern.
Okay.
11 Eastern.
When did you want to do this?
When let's say, 10 days before that. If you're all the disclosure.
Okay. 10 days prior to the 26th, Judge.
Yeah. Or as soon as you can. Once you make the disclosure, that might not be an issue. Right? Okay,
Possibly.
okay. Okay, we'll see y'all over in Wayne County.
Thank you, Your Honor.
But y'all need to work through this thing and get it down to some issues that a jury can be presented. So, I don't know. Okay, thank you very much.
Judge, could we call back the Moon's case?
Yes.
Judge, thought I might be excused.
Yeah, have a second.
Thank you, Your Honor.
Good enough.
Yeah, what you got here? Anything?
Judge, we did have some discussion on dates.
Can you hear us, Mr. Gibson?
Yes, sir. I can't hear you. Yes, sir.
They have agreed to give my client an additional 2 days on his weekend, August the 10th through the 11th. And then he could have the child August the 17th through the 18th from 8 a.m. to 3 p.m. while she's working during professional days. We had a discussion about setting it up so that we could avoid conflict in the summers where starting in next summer, and odd years that she would pick May the 1st, which week she wanted to exercise, and he would pick his May 15th. And then alternate that. So in even years, starting in 2028, he would pick May 1st and she would pick May 15th.
Is that what you agreed to?
Yes, sir.
You agree to that? Okay, we'll reduce it to writing and send it to Mr. Gibson and I'll enter it. Okay?
All right. Thank you.
Okay,
Thank you, Judge.
Yeah.
So do you copy the ordinance?
He needs to wait there for a while. What do you have? This is. This one, McGall versus McGall. You don't need this. Okay, we have an EPO and we have this motion here.
Your Honor, if I may, it's our motion, and before we get into the hearing on the EPO, if I may.
You speak up just a little bit.
Yeah, if I may make a statement to the court, it would seem that if we could get our motion addressed, that would largely address our concerns about the EPO. It just seemed like there's been a bunch of racket going on with each other, and that's what we're trying to avoid. And that's why Taylor filed the EPO. These people don't need to have any contact.
Well, this is where the hair pulling was going on and the other allegations. That's what.
No.
Give me the affidavit. We have the EPO file. I had this one commenced. I read the police report. Yeah, right there. Sunday the 5th during child exchange, my husband was threatening and aggressive toward me on the presence of our 4 young children. He refused to send my older daughter home and made me advances toward me, seemingly with the intention to push or shove me by telling me to F away. The last incident occurred in Clinton County Dispatch at 4:30. Officer Wilby was contacted after the altercation occurred. It's only the latest incident. My husband has a pattern of aggressive toward me in multiple text messages, phone calls. I'm scared that his life continue will result in physical harm to myself and my children. He's present. I do not know the extent of his capabilities from anger. That's what your clients.
Yes, Your Honor.
You deny this. Just yes or no, and I'll let you testify more from your back.
Deny it.
Okay, now. My goodness. Okay. Now, it's your position. You represent the slave. And it's your position that you think that some other orders would take place where she would feel safe. Is that correct? Could you
Yes, Your Honor.
decide some to see if he's in agreement? Have you talked to him about it? He's not represented by counsel.
Well, I will be happy to make that effort, Your Honor. I do think, with all due respect to Mr. McGall, he does need to be advised by the court that people need to, everybody involved, whether it's Ms. Flowers or Mr. McGall, need to go by court orders, and they don't need to.
Well, we need to get a court order, and once we get a court order, we'll go over abiding by it. Okay, so I don't know what has been abided by or hadn't been abided by. But if she is comfortable and does not feel like that there is an immediate threat to her, or that she'll be satisfied with this, I will do this.
We'll make an effort.
If not, we'll have a hearing. Do you want to say something?
Yeah, with that order about dropping the kid off, Child Services is involved with this situation and the state police. And I got told to keep the kid. I was informed to keep the kid.
But
I've never kept this.
By whom were you informed?
Child Services.
And what was the reason they said that you should keep?
There was some bruising on the kid. They'd come down and talk to him. And then some other stuff got through out there.
On one of the children.
Yes, and then
Who's the name of the person?
Austin McGall.
The person from social services. Wait, let me finish before you start answering, okay? Who is the person from social services that told you to violate the court order?
I didn't know nothing about this court order until yesterday. I've got the paper on the desk on it.
There was a separation. You're talking about the person being that's what it should be.
Is that what you believe? He's talking about the separation agreement?
Yes, the separation agreement.
I mean, how is he not abiding by the separation agreement?
Your
Don't
Honor.
make any accusations, just tell me.
Your Honor, the separation agreement clearly said, Mr.
No,
McGall.
just tell me what it says.
He is to notify her when he's going to be in Clinton County. There's in advance. The children will be with him during that period of time. That's not happening.
Well, just tell me what it was.
Well, that's the big thing. And then when they agreed on when the children.
Okay, here's the thing about it. Is the order as it presently sits sufficient if it was abided by? That's the question.
No, we've got to have some times. It's got to.
Okay, well, now that's what we need to do. So what we need to do is a modification of the agreement between the two, since you can agree on it without specificity. You agree you need to have specific times, so you won't have to doubt whether you're abiding by it.
And you can ask Mark Bell.
I'm not going to ask anybody.
Oh, I'm sorry.
I accept what you say. Let's don't go back and revisit things. What I'm trying to do is get specifics here. So you'll know what your rights are, she'll know what her rights are, and y'all will abide by them. It's obviously y'all can't agree on these sort of things. That's okay.
Yeah. Well, man, I was at drop off at 4 o'clock.
I don't want to talk about it.
Oh,
I mean, I accept that you might be correct about it. I'm not saying, look at me. I'm not saying you're not correct. I'm just saying that you don't have specificity in this, so we need to get all of the question out of it, so you'll know for sure what your rights are and what you're supposed to do. So you won't end up with an EPO or a court order or some police officer that you don't know coming up and getting involved in it, because these police officers don't want involved in it either. You can be sure of that, okay? So if y'all will step back in the room back there and try to work out some specifics.
We'll attempt to do so.
Well, that's all any of us can do. Hope springs eternal. So let's, when we talk, let's don't talk about what has happened. Let's talk about rules we can both abide by. And you might want to leave the door open. Go back there in that room, leave the door open. Okay. KFBMIC versus Ferguson.
Good afternoon, Judge. On the video, it's Alan Bertram at Bertram, Cox and Miller. We're the attorneys for Kentucky Farm Bureau Insurance.
Yeah.
We're looking for Sylvia Ferguson and Terry Ferguson.
Here they are.
Okay, good.
This is subrogation claim.
Yes, Judge.
Okay. And they haven't filed any answer.
Well, they did file an answer, Judge, that
It was just
said
up to
thought we
avoid
had
fault.
insurance.
Said what now again?
Said we thought we'd paid the insurance.
Yeah. How much of judgment are you seeking?
It's just a little over $5,000, Judge.
And you paid that out to who?
KFB paid this to their customer, Ariel Smith, to fix the car driven by Corey Smith.
Were y'all involved in a wreck?
Not in a long time, sir.
No, I don't. I'm the
She
national.
backed into somebody.
Do what?
She backed into somebody at McDonald's.
She backed in and they fixed it and they paid for it and now they want their money back. That's what this is about.
Yeah.
Okay.
That's what subrogation means. They paid for the thing. Now the insurance company's coming to you to pay them back because they paid for the claim.
Right.
And y'all don't really have any defense to that, do you?
Pardon?
Okay, so I'm gonna enter a judgment. Now, if you get Mr. Burke, can you give them a number they can call you to try to set up a payment plan or something with you? Or
Yes, sir, Judge. We'd be more than happy to do a payment plan that they can afford.
okay, well, I'm gonna enter the judgment and if you'll what's y'all's most recent mailing address?
105 Allen Street.
I'll be in Kentucky 42613.
Do what?
105 Allen Street.
105 Allen Street,
I'll be in Kentucky
Albany, Kentucky.
42613.
Okay, you're gonna get a copy of this judgment. And on that, there will be the attorney's name that's here, and that's Mr. Bertram Cox and Miller of Campbellsville, and his phone number is gonna be on there. If you want to set up a payment plan, you need to call him at that number. If you need some help doing that, if you've got anybody in your family that can hear better than you can or see better than you can or can help work out a payment plan, they can be on the phone with you. You can't have an attorney. Okay, so sir, it's your responsibility. So the judgment has been entered. And if you'll call and make an agreement with them, then they can do it. If not, they'll start looking for stuff of yours that they can pick up and attach. I don't know whether you have anything or not, but that's the way it'll work.
My
Okay.
car.
Well, don't give any suggestions what you might get. You know, he doesn't need any help. You know, okay, thank y'all for being here very much. Okay, the next case is.
Thank you, Judge.
Thank you. Have a blessed day. You got another case?
No, Judge, that does us. If I can be excused, I'll get out of your way.
You have a blessed day.
Thank you.
The next case is. I don't see. Serve Bank versus Lovell.
Good afternoon, Your Honor. A.C. Donahue standing in on behalf of Plaintiffs' Counsel. This is their motion to add a party defendant. They've apparently discovered that Mariner Finance may have an interest in this piece of real estate.
Do I have this? Just bear with me for just a second here. There it is. Okay, that seems fine. Just submit to the order.
Thanks, Judge. Have a good afternoon.
Let's know yourself. But Whitney Danielle Baker versus Jeremy Garrett.
Agreed order of dismissal.
Agreed order of dismissal. That's where the defendant, Tennessee Farm Mutual Insurance, said that they could not be included because they were out of state and then business here. It would be fine. Norris, Mercedes Christine Norris versus Jeffrey Ryan Norris.
Judge, we've reached a temporary agreement on the motions that are pending before the court. We've agreed to temporary joint custody with Mr. Norris getting visitation with the children supervised by his mother every Saturday at 7 a.m. to Sunday at 8 p.m. and then Wednesday at 2 p.m. to 8 p.m. And my client will drop the children off at his mother's residence and then pick them back up at the end of the visitation. We've agreed to a temporary child support amount for $200 per month starting July the 15th. And then we would like to come back to review to see if we can make any progress or if we need to address anything else with the court on September the 10th.
Okay. Is that what your client agreed to? Is that what you agreed to, sir? Ma'am, is that what you agreed to? Okay, if you'll submit the order electronically, we'll enter it. Okay?
Do that. Thank you, Judge.
Thank y'all very much. That it? Let's go off the record here.